6 states asked Supreme Court to declare Inec's pronouncement of Tinubu as president-elect null, void, and of non-effect. In what appears to be a copycat of an ongoing suit over the move by the Central Bank of Nigeria (CBN) to ban the use of some denomination of old currencies, 6 states of the Federation, Adamawa, Akwa Ibom, Bayelsa, Delta, Edo, and Sokoto, have dragged the federal government before the Supreme Court over the conduct, coalition, and announcement of the February 25, 2023 presidential and National Assembly election. The states want the Apex Court to declare that the pronouncement of the candidate of the All Progressive Congress, Bola Ahmed Tinubu, as winner of the February 25th presidential election and president-elect based on the election be voided by the court. They are seeking a declaration that the entire results of the presidential election conducted on the 25th of February 2023, announced by the chairman of INEC at the National Coalition Center, Abuja, in flagrant violation of the provisions of Section 25, 47 of 2, 60 of 1, 2, 4, and 5, 62, 64 of 4A and B, 70 and 148 of the Electoral Act 2022 governing the 2023 election nationwide general elections, particularly paragraphs 38 of the Conduct of Election 2022, were invalid, null, and void, and of no effect whatsoever. A declaration that the fundamentally flawed electoral process through the non-uploading of the results of each of the 176,974 polling units nationwide in respect of the presidential election and National Assembly elections held on Saturday, 25th of February 2023, were not in accordance of the Electoral Act 2022 governing the 2023 nationwide general elections, particularly paragraph 38 of the INEC regulations and guidelines for the conduct of elections 2022. In addition, they are seeking a declaration that the failure of the federal government of Nigeria, the Independent National Electoral Commission, to electronically transmit or transfer polling unit results in Form EC8A using BVAS by uploading scanned copy of the said unit result to the Independent National Electoral Commission Result Viewing Portal (IREV) after the counting and announcement of the polling unit results on February 25th, 2023, in conclusion, violates the provisions of the Electoral Act 2022 governing the 2023 nationwide general elections. They are also seeking an order of the Apex Court directing a holistic review of all results so far announced by the federal government of Nigeria through INEC, which were carried out other than through the manner prescribed by the provisions of the Electoral Act 2022, the INEC regulations and guidelines for the conduct of elections 2022, and the INEC manual for election officials. And as such, further orders as the Honorable Court may deem fit to make in the circumstance, the plaintiff also brought an application praying the Apex Court for an order directing a departure from the rules of the Apex Court in the interest of justice by directing for accelerated hearing of the substantive suit. Besides, plaintiffs also filed another application seeking for an order for abridging time for parties to file and serve responses for and against the suit. No date has been fixed for the hearing. The plaintiffs in the originating summons marked SC/CV/354/2023 as specifically asking for an order of the Apex Court directing a holistic review of all results so far announced by the federal government of Nigeria through the Independent National Electoral Commission (INEC), which were carried out other than through the manner prescribed by the provision of the Electoral Act 2022, the INEC regulations and the guidelines for the conduct of elections 2022, and the INEC manual for election officials. The suit filed by the Attorney General of Adamawa, Akwa Ibom, Bayelsa, Delta, Edo, and Sokoto State has the Attorney General of the Federation as sole respondent and was brought pursuant to Section 6(a), 14(2)b, 153(1)f, and 322(1) of the 1999 Constitution of the Federal Republic of Nigeria as amended. They predicated their case on the grounds that the collation of the national election results from the 36 states of the Federation and that of the Federal Capital Territory for the said 2023 presidential and National Assembly elections have not been carried out in compliance with the mandatory provisions of relevant sections of the Electoral Act 2022. According to the suit filed on February 28 by their lawyers, Professor Mike Oziekome, a senior advocate of Nigeria SAN, the agents and officials of the federal government and INEC failed to transmit the collated results as prescribed by the provisions of the Electoral Act 2022, the INEC regulations and the guidelines for the conduct of elections 2022, the INEC manual for election officials requiring transmission of the results by the use of bimodal voter accreditation system (BVAS) in flagrant breach of the relevant provisions of the Electoral Act 2022, the INEC regulations and the guideline for the conduct of the election 2022, and the INEC manual for election officials 2023. It was their submission that the non-compliance with the due process of law has led to a widespread agitation, violence, protest, displeasure, and disapproval from a wide spectrum of the Nigerian populace, including international observers, political parties, well-meaning Nigerians, and former head of state of the Federal Republic of Nigeria. They further claimed that the widespread violent protests, demonstrations, and rallies endangered the peace, order, good governance, security, and safety of the plaintiffs. The plaintiffs argue that the federal government through INEC is empowered by law to correct the elections due to technical glitches and errors arising from the conduct of the election with substantial effect on the electoral process in line with the provisions of Section 47 of 3 of the Electoral Act 2022 and other relevant sections thereof. The federal government of Nigeria has nonetheless continued to collate results for the presidential and National Assembly elections against the provisions of extant electoral laws and guidelines, notwithstanding the fundamental flaws identified in the process of the collation of the results and the public outcry that has greeted the entire electoral process. Whilst queries were being raised as to the failure or deliberate refusal of INEC to transmit the result electronically, INEC suddenly pulled down its portal harboring the regulations and guidelines, thus leaving the plaintiffs in the dark. Most Nigerians, including the government and the peoples of Adamawa State, Akwa Ibom State, Bayelsa State, Delta State, Edo State, and Sokoto State, are entitled to a proper and electoral lawful process and procedure that guarantees a free, fair, transparent, and credible election. There is no justifiable basis for the ongoing collation of results without compliance with the mandatory provisions of the law that mandatorily require the use of BVAS, electronic transmission to the IREV portal. Unless the Honorable Court intervenes, the government and peoples of Adamawa State, Akwa Ibom, Bayelsa, Delta, Edo, and Sokoto State, who have suffered and will continue to suffer irreparable hardship and damage of unquantifiable proportions by being denied the opportunity to participate fairly in a free, transparent, fair, and credible election, which can lead to a breakdown of law and order and thus endanger the public peace, security, safety, order, and good governance consequent upon the violent demonstrations and protests that have already started to take place in different parts of the country, including the plaintiff states, as a result of the fundamentally flawed electoral process, which does not represent the wishes of Nigerians and of the plaintiff states they submitted.